quite a bit of time, together today, which is great. And we hope to capitalize that and use all of your time very wisely. So my name's Chris, and I'm half of the team here at Higher Education Licensure Pros. We created Higher Education Licensure Pros just over 3 years ago in response to the July 1, 2020 regulations around professional and occupational licensure disclosures. We wanted to be able to support institutions of all types and sizes with this work. In particular, those of you who are a team of one trying to do, state authorization or compliance issues or accreditation or other things, and also be in compliance with this licensure stuff. So we know it is a lot of work and a lot to tackle and take on. My background, I've been doing this work within higher education for over 15 years now. Most of that time I spent at a large online institution called Capella University, headquartered in Minnesota, which is where I got to meet Nan. And I'll let you, Nan, go ahead and introduce yourself.
Thanks, Chris, and hi, everyone. I worked at Capella University where I met Chris from 2010 to 2020. I started out working across schools, helping them gain specialized accreditation, and then exclusively in the School of Counseling, providing operational support across all of their units, including admissions, faculty advising, data analysis, and curriculum development, and helping them to continue to meet quality assurance standards. Prior to Capella, I worked at the University of Minnesota for many years, primarily at the School of Social Work, and also gained my PhD there. As Chris said, last 3 years plus some months, I've been working with Chris on Higher Education Licensure Pros and learning all about licensure research. Back to you, Chris.
Great. All right, let's go over our agenda for this morning. I think you all noticed, but this session is being recorded. I did want to let you all know that this presentation will also be provided to you after today's meeting. So MEHC and SARA have been gracious, of course, to host us and invite us to do this. They will be letting you know when those materials are available on their website. So the slide deck and the recording afterwards. Okay, so what are we going to do together today? First, I'm going to provide an overview of the Title IV federal regulations, along with some SARA policy considerations related to professional occupational licensure. In particular, we're going to focus on the changes upcoming for this July 1st, make sure that everyone is clear on what those are and how those are going to impact your institution. So we do have quite a bit of time built in today for your questions. We welcome you to put those in the chat as we go throughout the day today. We will also have dedicated time here in about 25-ish minutes for you to ask your questions live. So feel free to do that through video or audio, or again, if you just want to put them in the chat, we'll be fielding those questions and answering them today. And then towards the end of our time together, we're going to turn to discussion. So as Sarah mentioned, one of the main focuses of these sessions is to give you all an opportunity to talk to each other, along with talking to us about the challenges that you're facing with implementation, thinking through some of those things. So we do hope to have a pretty robust discussion at the last 30 minutes or so of our time together today, and we hope that you can stick around and participate in that when it's time. Also, quick note, as we get started, you saw the disclaimer, this is not legal advice today. So there are many things related to this work that you probably will want your counsel to help weigh in on. So don't take what we're saying today, what I'm saying, as legal advice. Be sure to consult with your institution's own legal counsel around many or most of these decisions for this work. All right, thanks, Nan. So I'm going to jump in here to the overview of what is required for professional and occupational licensure compliance, in particular for federal Title IV regulations, along with SARA policy. I don't have the regulation language itself spelled out here on my slides. We will provide that. It is part of the appendix slides, so you'll get all that. And of course, we have links here as well. But that's because we like to try to break it down in a little more easily digestible terms rather than digging into all of these regulations themselves. So how do we break it down? Well, we think about this work really as three main responsibilities on institutions. The first is that institutions need to understand if their licensure programs meet the educational requirements to earn a professional or occupational license. And we'll dig into each of these here in a moment, but that first responsibility is really around understanding if or how your programs meet those educational requirements. The second responsibility is certifying, and this is the new one that's coming online for July 1 of this year. And it's related to the program participation agreement, which is the Title IV requirements for institutions. And again, we'll dig into this one, but know that this certify responsibility is new starting this July 1st, and it is a biggie. So we're going to talk about those implications. The third main responsibility is communicating that information. So communicating your understanding to different audiences at specific times. And this communicating responsibility is pretty close to what exists today, which was effective July 1st of 2020 under the current Title IV regulations that we're under. So there are a couple changes which I'll dig into, but that communicating responsibility still exists. That's the important thing to note here. Moving after this July 1st, still that responsibility to communicate. All right, so let's talk about this understanding, this first main responsibility that institutions have. You need to understand how or if your licensure programs meet educational requirements in each US state and territory where you are recruiting students, advertising that program, and most importantly, where you're enrolling students. So I'm going to break down this a little bit further here. What do we mean by licensure programs? Well, first thing is what's licensure, right? Licensure is kind of a shorthand term that really can be called different things depending on the state or territory or the profession or occupation that we're talking about. So you may also see something like a certification or certificate, endorsement, authorization, registration. Essentially, anything that a state or territory government issues that's required for employment in that occupation or profession in that state, that's what we're talking about. So it's something that's required for employment. It's something issued by a state or territory government entity, whatever they call that thing, that fits into this regulation, into licensure. And I'm gonna use licensure throughout the day today. But again, just remember when you hear licensure, it could be called something else, depending on the location and the particular profession or occupation. So what's a licensure program? Well, US Department of Education does not give us a list of what those licensure programs are. It's really up to each institution to figure out which programs you're offering could be related to one of these professional or occupational licenses, right? So unfortunately, that piece itself is going to take work just to get clear on which of your programs are licensure programs or not. But again, the key is going to be if it's related to a required state or territory government issued thing, whether it's called a license, certificate, certification, endorsement, whatever it is. We do have some guidance from US Department of Ed around how to kind of identify what is a licensure program. And that is kind of two things to keep in mind. So has that program been designed to lead to that license, or a license, I should say, or is that program being advertised as preparing a student for that license? So those are key points to keep in mind as you're working through your own programs to figure out which one should be on your list of licensure programs. All right, so I think that's all I'm going to say about those for now, but let's talk about this first bullet here on the slide. So we've been hearing and still hear from institutions kind of this misunderstanding that these regulations only apply to distance education programs. That is not true. These regulations apply equally to all types of programs. So when we're talking about these responsibilities around understanding, certifying and communicating, that applies equally for all of your programs, no matter how you're delivering them and where you're delivering them. So there are some nuances around who is a distance education student that come into play for the new certify responsibility, and I'll talk about those in a moment. But again, keep in mind here, these apply to all of your programs across the board. So you do need to understand if your programs meet or do not meet the educational requirements. Right now, under the July 1, 2020 regulations, there's kind of this third category of not determined or no determination made, right? So the concept is an institution hasn't really dug into what the requirements are for licensure in other states and territories and haven't compared their programs to see, if it might meet it or not. Um, Under the 2020 version of the regs, this is perfectly fine because in your communicating responsibility, you can disclose that you've not determined. And so many institutions that we've been working with over the past several years, have taken this approach. So right before July 1, 2020, you may have put up, disclosures on your website. And for many states and territories, you were listing not determined. You could still have that same list today, where you haven't really dug in and determined things. Again, under 2020 regulations around that communicating responsibility, that is fine. You're technically in compliance with the Title IV regulations, at least in that capacity. But this will be changing. This is changing again because of the new certify responsibility that I'll talk about in a moment. So you could still have scenarios where an institution has not determined. So you're not trying to figure out what those educational requirements are in other states and comparing your program, but it's going to probably be in fewer scenarios where that's likely. So maybe for some of your face-to-face, truly campus-based programs, if there's no online coursework, you could still have states where you're not going to be figuring out what's going on in those states and making those determinations. Let's shift over to the certify responsibility. Thanks, Dan. So I mentioned it before, but this is the new big change for July 1, 2024. And this is related to the program participation agreement. The PPA is basically that master contract that every institution needs to sign with the US Department of Education in order to participate in the federal financial aid, the Title IV program. So the PPA itself has been around for a very long time. If you're not that familiar with it, you probably have folks that work in your financial aid office that are very familiar with it, because this is something that needs to be kind of reinforced and signed again in some sort of cadence of time. So there's a different window of time for when that happens, depending on different scenarios at your institution and the circumstances. But again, it's been around for a while. So what's changed is that Department of Ed has added a new section to the PPA that is related to professional and occupational licensure. And you can see that here on this slide. So starting July 1st of this year, each institution must certify through that PPA certification process that any program you're offering that prepares students for licensure, or again, whatever that's called, that it actually does meet the educational requirements where your institution is located. So Kansas is probably the easy one for all of you to say, yes, our program meets Kansas's requirements. And you also have to be able to certify that it meets those educational requirements where your students are located at the time of initial enrollment in the licensure program. Now, there is an exception that Department of Ed has created here around a written attestation. So if you have a prospective student or an applicant who would like to enroll in your program, but they're located somewhere where the program does not meet the educational requirements or you haven't determined, you could still enroll them as long as they go through that written attestation process and complete a written attestation for the institution that says they want to seek license and employment in a meets state or territory after they finish your program. And we can get into more of the specifics around that if people want to. I think we should, especially if some of you have started thinking through your written attestation process and what the language around the actual attestation is going to be. We can dig into that here later. But that's the basics of it. You have to be able to certify that the program meets educational requirements where the institution is located and where the students are located at the time of initial enrollment, or you can do that written attest, have them complete a written attestation. I did want to pause here and talk about the distance education consideration. So I mentioned before, this is kind of, I think, where the confusion comes from is around this new certify responsibility. So in the regulation itself that Department of Education has created, they do use distance education to identify the groups of students where you need to be able to certify that they meet that your program meets the education requirements where the distance education students are located. So the reason that I'm not emphasizing that on this slide in the first place is because of the definition that the US Department of Education staff is using for distance education. So staff have indicated that they will be applying the definition the Department of Ed put forward in a May 2023 Dear Colleague letter that is really focused around accreditation and distance education. But in that letter, it indicates that a student who's taking one or more class online is considered a distance education student. So, kind of how this practically plays out, right, is that if you have an opportunity for students to take one or more class online during their first term of enrollment in the licensure program, then it kind of kicks them into that distance education definition under this new PPA certification responsibility. So again, it's much more broad than truly your distance education programs. And we know, talking to a lot of institutions, that there are options or opportunities for any student to take, an online section of a course, whether it's a gen ed course or whatever kind of course it is. But because those opportunities exist, it really makes this definition pretty broad here on who we're talking about. So if you can think about it more in terms of students rather than focusing on the distance education piece, that's going to set you up for success here as you're working through all of the issues related to getting ready to certify for your programs. And I'll just make a note because we have it here on this slide. We have provided some examples of different student location policies and written attestations. Um, this is the type of thing where it's going to be very much determined on your institution's programs and your student populations, even your geography, if you're close to a state border or not, if you have students commuting across that state border for these programs. A lot of factors need to be considered when you're crafting your location policies or written attestations for this. And again, I hope we can dig into more of that here with the discussions later today. But we are providing those just as a starting point. I know that it can be helpful to have something to look at least as you're thinking through these things and getting ready to craft them for your institution. So the location policy is important. You should have one in place already because that's part of the 2020 communicating responsibilities that already exist. But if you don't have a student location policy that it's used for these purposes, that's something that you'll want to turn your attention to pretty quickly because it's still required for the communicating responsibility, which I'll talk about here in a moment. But that student location policy is directly connected to this new certify responsibility. So again, wherever your students are located, and that's determined by your institution's own student location policy, that's where you have to be able to certify that your program meets the educational requirements. So that student location policy, even more critical with these changes for July 1st. And the Department of Ed has not dictated, what the policy needs to be, or even what needs to be included in it or not. But rather, we have some kind of rough guidelines here to keep in mind that you do need to have a student location policy. It needs to be something that is applied consistently at your institution and something that is, updated and reviewed as part of regular cadence as you would any other policy for your institution.
Chris, this is Nan. So
Yeah,
Christine put a really interesting consideration in the chat. Do you want to take a break right now and address that?
sure, let's do that.
Okay. She says, our understanding thus far is that students have to attest that they want to seek employment, that it's not enough that they intend to seek licensure in Kansas. This makes a big difference for our School of Education programs where students often seek initial licensure in Kansas and rely on reciprocal agreements to seek licensure in another state. But they are not necessarily planning on seeking employment in Kansas. Our understanding is that this means they could not use the attestation process.
Yeah, so I would say my understanding is the same as yours, Christine, that the attestation is not just about licensure, it's about licensure and employment in a state. Um, there are some other considerations here related to reciprocity agreements and licensing compacts that we can dig into a little more here, but so I guess I'm just trying to say there are potential other options where you wouldn't have to totally stop enrolling students from outside of Kansas for your education programs. There are other things that might help you be able to continue enrolling them because they could live in somewhere that is a meets scenario based on reciprocity agreement, which is something new. So Department of Ed has kind of thrown in this notion that institutions can utilize, compact agreements or reciprocity agreements related to licensure to help you in determining if your program allows your graduates to qualify for a license in other states and territories. So my understanding is the same as yours around the attestation piece. And let's put a pin in that compact and reciprocity, but we'll get back to that in a moment. All right, so I'm going to keep moving here to the communicating responsibility. This is the third one. And again, not a whole lot has changed from that existing responsibility that was put into place July 1st of 2020. So we still have public disclosures required as well as individual direct disclosures. For the public disclosures, this is really the most notable change. So the Department of Education has removed that not determined or no determination made category from the public disclosures. So the new regulation that's effective this July 1st says that institutions must disclose those states and territories where they've determined that their program meets the educational requirements and where it does not meet the educational requirements. So again, not determined is no longer required to be listed on your public disclosures. We know in talking to lots of institutions that many are still going to choose to disclose that. So they'll continue to have that list up on their website. But again, it's not required, not something that you have to do for Title IV compliance purposes. So what does that actually mean then, right? What do you have to have in your public disclosures? Where again, it needs to be listings of those states where you've determined that the program meets educational requirements and those where it does not meet. This could be all 59 states and territories for some programs or for some institutions. Again, depending on what type of program we're talking about, where are you attracting students from? I think the modality does come into play here. Obviously, if it's a distance education program and you're enrolling students from lots of other states versus if it's your on-campus face-to-face program where students are coming to Kansas to your campus to take it. So that's an important consideration as well. Something to keep in mind here, which is not in the regulation itself, but again is information coming from Department of Education staff. It's not just about enrolling students. It's also about where you're advertising that licensure program or where you're recruiting students for that licensure program. So if you're going to be advertising and recruiting, you need to do that in states where you've determined that the program meets educational requirements. Department of Ed staff has indicated their expectation is if an institution's actively advertising or recruiting for a program, then it needs to be somewhere where those students can meet the educational requirements and qualify for that license and be able to be employed afterwards. So things to keep in mind again as you're figuring out which states or territories would need to be on your public disclosure list moving forward. I did want to make note here of SARA policy. So State Authorization Reciprocity Agreement Policy 5.2 has been around for a while. It's really aligned to the 2020 version of these federal regulations. So it's aligned to this, the communicating responsibility. What the policy does, a couple of things. So it says if you're indicating that you've not determined for a particular state or territory, first, the expectation is you make all reasonable efforts to try to determine if it meets or doesn't meet. And then if you're still indicating not determined, you need to provide the board contact information for that state or territory licensing board or agency. So SARA policy, again, it's connected to the 2020 version of the regs. I do know that there have been several proposed revisions put forward in the current SARA policy modification process that would address this policy 5.2 and change it either to align it more to the latest version, this July 1, 2024 version, or just to make it more aligned generally with the federal requirements rather than having some of these additional nuances that exist today in the policy. So more to come on that. The policy modification process is continuing and it'll extend beyond July 1st. So when the final policy revisions are announced, probably want to check to see if there's something related to the licensure policy 5.2 that has made it through that process and been revised. All right, so in addition to public disclosures, we also have those individual direct disclosures. Really, Department of Ed changed nothing about these. So we end up with a mismatch between the direct disclosures and the public disclosures around that not determined or no determination made. So the individual direct disclosures, as I mentioned before, are connected to the student's location or prospective student's location, and that is dictated by your institution's student location policy, which you will need to make sure you have and have that updated. So if that student location policy says the prospective student or applicant is located in a not determined or a does not meet state or territory, then you would need to send them an individual direct disclosure. These are typically done through email that indicates you're located in a does not meet state, or we've not determined if our program meets the educational requirements in your state. As a side note, under the new PPA certify responsibility, you would also need to send these same prospective students or applicants the written attestation. So they would need to go through your written attestation process, provide that document, that written attestation to you that says, well, I actually intend to seek licensure and employment in this particular meets state rather than where I'm currently located that does not meet or not determined. So current students, again, same as 2020, you have 14 calendar days to send them a direct disclosure if something changes and they are located and it does not meet state or territory. Again, this is all dictated by your student location policy. So they could change locations, right? They could move while they're enrolled in your program. That would trigger this. It could also be something changes with the state or territory's requirements and your program now no longer meets it. Or maybe you revise your program in some way, or it held a specialized accreditation and now you no longer hold that accreditation, whatever it is. If it changes to a does not meet situation, you have 14 calendar days to send out those direct disclosures to students located in those does not meet places.
Chris, we have a few questions on licensure, definition, and advertising. So the first from Kathy, state licensure or certification does not include industry certifications, correct?
Correct. Right. So for these purposes, under these Title IV regulations, not applicable if it's only that private industry certification.
From Christine, what about athletic recruiting that's not for specific licensure programs?
Right. So this recruiting and advertising piece is tricky because, again, we don't have anything in the regulation itself around this. The recruiting and advertising is coming from Department of Education staff at this point. I'm hoping that in written guidance that we're anticipating the department will release soon, this week, hopefully, that they'll have some more color and clarity around this, exactly what they're talking about. But my understanding from, again, this is email communication that I've had with department staff and then others I know who have had similar responses from them. It's really about for the specific program. So I don't think the department is trying to, quash your ability to recruit generally for your institution in other states or advertise, broadly your institution in other states. It really, I think, is really going to be about those particular licensure programs that don't meet the educational requirements.
Right. I think you might have answered Linda's question, but I'll repeat it just in case. Isn't advertising on the web everywhere? What about this?
Right. Yeah. Great question. Right. Like I'm hoping that there'll be some more nuance and clarity provided when the Department of Ed releases their written guidance around this. But I really don't think that they're trying to totally squash your ability to talk about your institution, or even about the types of programs you have broadly in on the web anywhere. I think that that would just definitely not make sense. So but if you have things that you do for a particular licensure program that's being broadcast widely anywhere on the web, this is something we'll want to pay attention to if the department is, the expectation is that you're somehow going to limit that to only those states and territories where you've made a meets determination. All right, so some of you may have heard about this. Announcement came out from Department of Ed just a couple of weeks ago here that's related to this. So an electronic announcement was released, basically doing a couple of things, but the main thing to note here is the small window the Department of Ed has opened for some institutions that are in unique circumstances outside of that institution's control. If you're not able to fully comply with the PPA certification requirement, so that new certify responsibility by July 1st, that the institution could document all of those reasons why they can't fully comply, what those circumstances are, and should the department take an enforcement action on that institution between July 1st and January 1st of 2025, the institution could use all of this documentation, this information in their defense of that enforcement action. So, what does this really mean? Well, it's important to note this is not delaying the effective date of these regulations. So these changes all still are effective July 1st, including this new PPA certification requirement, that certify responsibility. And also, this is only specifically for that new PPA certification responsibility. It's not extending anything with public or direct disclosures. That communicate responsibility still exists. You could not defend your non-compliance with that should some enforcement action happen after July 1st, using this criteria. So I think practically my takeaway from this is, there are going to be potentially some very limited situations where an institution would want to be documenting all these things because they're not going to be in compliance by July 1st. But for the majority of institutions, this really is not going to be applicable. You should plan to continue working towards full compliance on July 1st. And your expectation should be that you're able to certify for all of your licensure programs on that date. Some of the unique circumstances outside of the institution's control, in those very rare cases where an out-of-state licensing board or agency does review and approve out-of-state programs, again, this is very rare, but if you're seeking that approval from the out-of-state licensing board and the time frame for that is pushing out beyond July 1st, that may be one of these circumstances. But even with that, I'll just caution to say, Department of Ed staff, including from their Office of General Counsel, has said, we judge all of these on a case by case basis. And so they're not going to provide like a list of what would qualify. It's all going to be on, what the facts are, what the situation is, what steps that institution taken to try to come into compliance by July 1st. And the department would look at all of those things that have been thoroughly documented by the institution and then decide at that point if this would be a defense to that enforcement action or not. So I'll leave that one there. But in case you had heard about it, I know some people were like, "Ooh, is this a delay? Can we just not do anything until after July?" That's absolutely not what it is. It's not a delay in effective date, and pretty much everyone should be still doing what you've been doing to get ready and be prepared on July 1. Great. All right. Well, we have shifted now into our designated time for questions, and thank you for the questions we've received so far. Other questions are welcome. Again, you can put them in the chat, or if you want to come on video or audio and ask those, we've got some time set aside for that now.
Hello, it's Christine from St. Mary again.
Hi, Christine.
I have a question about when we might know about the reciprocity agreements. I think it was the other Christine actually mentioned with a lot of our teacher eds that we require them all to get their state licensure in Kansas and then use reciprocity agreements to get their teaching licenses in other states. So do you know when we might hear about that?
Right. So we have some information about that now that Department of Ed has provided. So in the commentary that they released with the final versions of these regulations back in October, they actually talked through a scenario just like that. So somebody completes an out-of-state teacher preparation program. They seek a license from that state, so Kansas in this case first. And then they use that as a basis to apply for a license in another state using a reciprocity kind of mechanism. And Department of Ed's commentary indicates that again, this is information that an institution can use in order to help you decide if your program meets the educational requirements or not in other states. So for teachers in particular, right, we're talking about this thing called the NASDEC Interstate Agreement for Educator Reciprocity. Generally applies for classroom teacher type programs, but it also applies to like school administrators for some states and territories, and also school support personnel like school counselors, for example, things like that in other states and territories. Not all states participate for all of those different types of educators, but some do for all and some do for just some. So you can use that information as you're looking at, okay, other states and territories, how do our graduates actually qualify for a license in that state? And this kind of mechanism of using the NASDEC Interstate Reciprocity Agreement can be considered as part of it. So I'm also hoping that with this written guidance that the department is putting out, again, hopefully very soon, that will be something that they'll make more clear in that written guidance. I know that folks have been sending in questions related to this, and I think the idea is that the department will be releasing some sort of Q&A, frequently asked question kind of document. So hopefully this one will make that. But one thing I do want to caution is, I've heard from some institutions like thinking about different professions, let's say the nursing compact, right? So they say, well, our state's in the compact, so can't we just say that our graduates can meet the educational requirements in all the other compact states? It's really not that simple. So I will just caution you all to say, I think this compact and reciprocity agreement information is good because it's acknowledging there are kind of different mechanisms and ways for somebody to be licensed that is coming from an out-of-state program. But I don't suggest that you totally rely on the fact that your state participates in one of these compacts to just automatically say meets for all the other states and territories. There still needs to be some research done to understand exactly how those receiving states are looking at people who are applying through those pathways or mechanisms. And then also, most importantly, is what does that compact actually enable a graduate to do? So the nursing compact is an example, right? If someone qualifies and earns a multi-state license in Kansas as a registered nurse, they could practice in any other compact participating, on their multi-state license. That's the primary reason why that compact exists, to allow nurses to practice across state lines without having to go through a full licensing process elsewhere. So that's great. But if you're talking about a graduate from your Kansas nursing program using some sort of license from Kansas to qualify in, let's just say, Illinois, um, it's not going to help in that way, right? So that person moves to Illinois, they are going to have to seek a nursing license from Illinois. So if they're living in another state, they can't continue to work on their Kansas multi-state license. So again, just a caution here, I think you have to really think through, how does this play out for graduates of our particular licensure program? What does that compact enable them to do? Or what is it really not helping facilitate as far as qualifying for a license, meeting the educational requirements for a license in another state or territory? Great. I see Nan put in the chat, the primary contact for Department of Ed. Her name is Vanessa Gomez. So thank you, Nan. Any of you can contact her with questions. I think how the process has been working is, she takes those back to others on their team. They discuss, they make a decision, and then get back with the response. So it has been taking a couple of weeks typically, or maybe a few weeks to get a response, so that they have the time to consider them and then provide that response in writing. Other questions people have?
Well, hi, I'm Jennifer Ball from Washburn University. I guess this kind of goes back to the 2020, and then relevant to some of these changes here. So back then, when we were collecting, the meet and does not meet and not determined, I remember specifically back then, and talking with the folks that were helping us implement then, the idea that, like, this sort of blanket statement that we don't guarantee our stuff meets licensure elsewhere, was not enough. We were told very specifically, like, you gotta be more proactive than that. You gotta know where your students are, where you're, advertising. You have to. Okay, so we just decided at our institution just to, like, list every state and say meets, does not meet, is not determined for every program that we have licensure with. Now, but when I look around at other institutions who shall be nameless, I often see that blanket, we don't guarantee it, and with no information about by state or these other boards, or where students could get more information or anything like that. So I guess I'm kind of thinking about this same thing here, as far as now they're saying, I guess we don't have to say not determined. So then that means kind of any state we haven't determined, we just leave off of our reporting. And so then we're down to what, if we have a student in that state, and if we advertise in that state, those are the states that we need to focus on. Does that sound about right?
Right. So definitely you'd want to disclose publicly those states where you've made a determination that it meets or does not meet. Some institutions may already have a longer list than others, right? Like if you've been engaged in this work for a while, researching other states' requirements, comparing your programs, trying to decide if you meet or don't meet, like that institution would already have maybe a longer list than some of these others. who have just said, we meet in Kansas and then put not determined for the other 58. So I did want to make sure that that's clear. If you've already made a determination about a state or territory, one way or the other, you need to disclose that because you have that information. So you can't just pretend like you never did that, which is maybe a little unfortunate, ding against those of you who have been engaged in this work for longer than some other institutions. But for any of your states or territories where you've not made a determination yet, you're correct that under the July 1, 2024 version, you don't have to include those on your public disclosures anymore. That's no longer a requirement. As I mentioned, some institutions are going to continue to disclose them just so that they can provide, basically all the information they have available will be right there on their website. It'd be clear to a prospective student that you haven't tried to compare your program. You don't know if it meets in their state or not, just to have more information out there, but you're not obligated to include those on your public disclosures anymore. You would be obligated still to send a direct disclosure to that prospective student prior to initial enrollment in the program. If it's a not determined state or territory, you would have to send them that direct disclosure that says that.
Okay, thanks.
Hello, Christine from St. Mary again. I just thought of another question because we are starting a new certificate program. It's a non-degree certificate program for 2 different nurse practitioner tracks. So do non-degree programs fall under the umbrella of licensure programs?
Anything that is Title IV eligible falls under this. So I would assume that you'll be offering Title IV for these.
Yes.
Yeah.
Yes.
Yeah.
Thank you.
So it's a yes. Yep. You're welcome. Kind of following up on that, some questions that we get sometimes are, well, what if I have students who aren't using Title IV for these programs? Do I have to worry about them or are they included? The answer is yes. So this is really focused on the program's eligibility to participate in Title IV and not about the individual students who could potentially be accessing Title IV. So, if you have some sort of, let's just say a nursing program, but you have a significant portion of your students who don't use Title IV, maybe they're, privately paying or GI Bill or whatever it is outside of Title IV, it's still a licensure program. It would still be on your list and you would still have to be able to certify that it meets the requirements where all of those students are located, even if they're not a Title IV participating or accessing student themselves.
I have a question. This is Andra from Emporia State, and I want to just make sure this is clear for me. This type of disclosure has to be provided at the time of initial enrollment for students. So, but a few minutes ago, you mentioned something that confused me. In essence, you said, well, maybe these students are moving around. So then at some point you'll have to, when they enroll, you have to make sure that in case they're moving from Kansas to Oregon and we haven't been able to determine that our program meets licensure requirements there, then we need to tell them. Is that the case? I thought it was just initial enrollment period.
Right. Thanks for asking the question to clarify, Andra. So it's both. The direct disclosure requirement applies at the time of initial enrollment into the program. So you have to send that direct disclosure to prospective students or applicants or wherever they're at in your process of enrolling. But before they're actually enrolled, you have to send that to them if they're located in a does not meet or a not determined state or territory. And then if for your current students, once they're in your program and enrolled, if something changes and they are located in a does not meet state or territory, you have to send them that direct disclosure that says that. So if you have, again, if you have a student who relocates, they're moving to Oregon, or maybe Oregon was a meets to start with, but then Oregon changes their educational requirements for licensure and your program no longer meets it, then you would need to tell all those Oregon students within 14 calendar days of the institution becoming aware of the change. You have to send out those direct disclosures to current students.
All right, thank you.
And one thing I don't think I touched on was that initial enrollment. So initial enrollment is another really important term that Department of Education has not provided a prescriptive definition or point in time around. So what we do have is kind of some guardrails the Department of Ed provided, which is essentially initial enrollment is at a point in time of a substantial financial commitment by that student or applicant. So when you're trying to figure out what point in time is initial enrollment for your institution, there actually is quite a big window of opportunity or window of time for most institutions. We've been talking to many through these SARA sessions and then other things we've been doing as well. And it really is a broad continuum. So we know some institutions are setting initial enrollment as very close to or even this first day of the start of classes of that first term of enrollment. Others are putting it closer to the point in time where someone's applying for the program. So before they've even actually been admitted to the program, but where they're applying. And then of course, kind of lots of different points in between, including that point of program admission, I think is another common one that we're seeing that people are using for initial enrollment. And I know this gets complicated because you could already have enrollments defined for other purposes, related to Title IV reporting or other things. But there is, again, some flexibility here for these purposes for the disclosures along with that PPA certify responsibility. It's connected to initial enrollment. So it's important to know what your institution considers as that point in time of initial enrollment for these purposes. And some institutions are choosing to put a definition right in their student location policy that says we consider, initial enrollment to be this, and they'll list kind of the specifics that they're using. Others are just making that more of a internal kind of process, point of information rather than explicitly including it in that student location policy itself. Yeah, Diane, go ahead. I see your hand up.
Thank you, Chris, for your explanations today. I'm trying to take some notes. I will have several other people watch the recording, but I'm not typically the one who leads this effort. I have some folks on vacation. So if I could read down just a very brief summary list and scream out if I've got something wrong, I guess.
Sure.
New for July 1 of 2024. It is not required to list all 50 states and 9 territories. However, you must list all states where students are at their time of initial enrollment. And you cannot enroll students located if you have determined does not meet or not determined unless they've signed the attestation. So far, so good?
So far, so good. Yep.
Great. Public disclosures need only include meet or does not meet. Not determined is no longer required. You must list all states where students are from, and you must list all states where you advertise or recruit. And I'm sorry, you can only advertise and recruit in states where you meet.
Yep, correct.
Okay, and then the individual direct disclosure is still the 14 days notification. Okay, thank
Correct.
you.
Yep. And sorry, you got the short straw, Diane, and you had to come to this today. So hopefully it's useful. Go ahead, Christine.
Appreciate it. I've was in this and then out and back in.
Yeah.
Yes, can you hear me?
Yes, go ahead.
Okay. Christine, I'm from the University of Kansas. One clarification. So understanding the difference, the flexibility on the definitions of licensure. My question is about necessary for employment. So a question came up about accounting, CPA. So the programs make a claim to prepare for the CPA, but not all students necessarily go on to get the CPA, and they can seek employment in their field without securing the CPA. So would that be, I went and I looked at a bunch of other institution sites and they include CPA. So we're planning on including our accounting program, but I just wanted to use that as an example. What about that kind of scenario?
Mhm. Yeah, that's a good one, Christine. Thanks for bringing this one up. Accounting is now one of the more tricky programs to deal with because of this new PPA certification responsibility, right? It's not just about disclosing information anymore. You have to affirmatively certify that the program meets educational requirements in the state where your institution is located and where all of your students are located. So this can and does become problematic for accounting, in particular bachelor's programs in accounting. The reason why is all states and territories require a minimum of 150 semester credits to qualify for a CPA license. So many states will allow people to sit for the exam with less than 150, but to actually meet the educational requirements for the license, they have to produce 150 semester credits completed. And most bachelor's programs are not 150 semester credits, right? So then we get into this scenario, you probably don't even meet Kansas's requirements for the CPA because again, your bachelor's program probably isn't 150 semester credits. I know there's some exceptions and some of you may offer one that's 150, but so what do we do with this kind of program? I think for bachelor's degrees in accounting in particular, a lot of institutions are looking at how they've been advertising it. So what language are they using on their website and in the program descriptions and elsewhere, and revising that to make it clear that this is a step in the process that could help you down that path, but this is not a licensure program. Our bachelor's in accounting is not a licensure program. So they're putting really clear information around that just so that there's not confusion by prospective students. And then once they have that clear language in the program description and on your website and in advertising, basically that gets removed from their list of licensure programs. So the bachelor's in accounting is no longer a licensure program, which means these requirements do not apply. They don't have to certify through PPA certification, and there would be no disclosures provided for that. So I think that's one thing I wanted to point out specifically about the bachelor's in accounting in particular. Masters can also be tricky. I think some institutions set these up differently, right? Like you might have a clear pathway for students where they're moving from your bachelor's to a graduate program, or you could have very specific prerequisites that someone who's enrolling in your graduate program has to demonstrate that they've met. If you have one of those two scenarios, then I think you could make those determinations if your program or if students who complete your program would have the 150 semester credits that are required. If you set up your admissions differently, that might be a real challenge for you to be able to make a meets or does not meet determination for these accounting offerings. But I guess more broadly, I did want to talk about this idea of required for employment that you brought up, Christine. So thanks for that. I personally am still struggling with this one, and I've heard lots of people talk about it, not just for accounting, but other professions as well, like engineering, for example, of this notion of, well, people can still work in the field. They can, do other things that don't require the license. But I struggle with that because, honestly, that's true for any of these programs, probably. Somebody could complete your teacher's program in elementary education, and they could go work at a private school that doesn't require them to hold a license. Or they could use that degree in some other way and, maybe do private tutoring or, work for an online school based in another country teaching English. I mean, of course, there's lots of things people can do with any of these degrees. But why I'm struggling with it is I always come back to this designed and advertised for, right? So have someone at your institution designed that program to prepare or lead to a license? And I think for many of these programs, that's a yes, even if it's an engineering program where a license isn't required to be an engineer. But if you've set up your program in a way that's the curriculum is preparing them for the licensing exam, or it's preparing them to meet the education requirements to be a professional engineer down the road, then I think it's kind of disingenuous to say that this isn't a licensure program. So I'm getting on my soapbox now and I'll stop, because reasonable people can come to different conclusions on these things. Again, there is no list that's been provided by Department of Ed that says, these types of programs are licensure programs. It is up to institutions to determine what you consider a licensure program. But I would, again, come back to the design. What's it's been designed to do? What is that curriculum aligned with? And what is it being advertised and marketed for?
Yeah, no, I appreciate that. That is actually exactly what I've been relying on in conversations with a couple of units that wanted to make that argument. And I was able to point to the language on their website that talks about how they prepare for. So that's again, not super clear, but that's what we've been relying upon to make that decision as to whether they should be considered licensure or not.
Yeah. Yeah. And I think that's the best we have at this point in time. Again, maybe we'll get something a little more from the department. I don't anticipate they're going to release a list of types of programs that they consider licensure programs, but maybe they'll give us a little more in this written, FAQ that will be released around some of these specific programs like accounting and engineering that keep coming up as, I think, the big struggles for institutions as, how are we going to handle these? Are they on the list or not? Well, I'm just noticing the time, and I do want to have time for discussion. So, Nan, if you wouldn't mind, we have a poll that we wanted to kind of start things off with. So if you haven't used Slido before, it's an online polling service here. You can scan the QR code that's up on your screen and use your mobile device to take the poll right there. Or if you want to go to slido.com and then punch in those numbers 2561206. We'll just wait a minute or so here, and then Nan can present the poll, and it'll show in real time what you all are choosing on your end of it. So again, you can go to slido.com 2561206, or go ahead and scan that QR code and use your phone or mobile device to take it. You want to go ahead and present the link, Nan? We'll see what results are coming in here. Thank you. All right, so we've got researching educational requirements is the leader so far. Integrating this information, these requirements in the enrollment and admission process, that's a challenge. Updating your policies, and smaller set of challenges around documentation and comparing your programs to state and territory requirements. And then some of you are not getting full support from your leadership, which we know can make this work particularly challenging, because it does take a lot of time and effort and resources and a team to do this. So having that support from leadership is key. It looks like our winner is challenges with researching the educational requirements in other states and territories. I will say I'm not surprised. This one has been the top of challenges, I think, for every state session we've done so far. We've done 4, maybe 5 of these. So you all are in good company if this is the challenge that you chose, researching those educational requirements, because it is very time consuming. You know, any of you who have done this work or helped project manage this for your program directors or faculty or others to do, you know, it takes a lot of time. There's not really shortcuts. You do have to go out to each state or territory licensing board or agency, find their law, so their rules, regulations, and statutes, read through all of that, read everything on their website, contact them sometimes to clarify what's going on. So it's quite a process. And then you multiply that by 50 plus, and then multiply that by all of your licensure programs. So we're talking about thousands of hours of work here to do it. So thanks, Nan. I think that's a good segue into our discussion. I have some questions. I think maybe these questions might have been sent out to you all before, but before we dive into these, I am curious if anyone would be willing to share about your research process, because that is the biggest challenge for the majority that answered that poll question here today. You know, how are you tackling it at your institution? Do you have your program directors or faculty engaging in that research work? Are you yourself doing it? Do you have others within your office or team that are doing it? I know at least some of you on this call today are members of the Bookmark, which is our online database that we've created that includes education requirements for 59 states and territories. For, I think we're close to 75 license types now. But anybody willing to share a little bit about how you're tackling that research work? Go ahead, Christine.
It's me again. It's always me. We are members of the Bookmark, and so that's actually why I did not put that as my biggest challenge. So I currently work in institutional research and assessment, so I'm kind of spearheading this, but we have our program directors who are the ones who are taking the brunt of this blow of these regulations. And so I meet with them. I probably need to meet with them more frequently as we get closer to July 1 as well. But I meet with them a couple times throughout the semester, and that they are responsible for going into, we have a Teams group that we use for all of this work. And I put all of our Bookmark regulation, or all the Bookmark state lists, the CSV files in there. And then I've encouraged them to save their own copy so they can make notes. And something that's worked well, especially for our nursing programs, is they take each state, and our person who's doing the undergraduate portion of it, at least, she makes a tab for every single state. So there's 50 plus tabs in her file where she goes through and she just copy and paste where it's transposed. And she puts everything, if they need 3 credit hours of whatever pharmacology, she puts that exact class down and that type of thing. So that's been going a lot better. It's still very time consuming for them. But that's how we've been doing it. And then she gets me the list of meets and does not meet, that type of thing.
Thanks for sharing, Christine. Yeah, and as I mentioned, there's not a whole lot of shortcuts to this work. And I think Department of Education, when they created these regulations, really didn't have a good understanding of the amount of work this is, for how long it takes to compare a program. Once you have the research done, right, it's just still a tremendous amount of time to dig in and compare, because it often is matching up particular classes that are required in the program to a specific content area that a state's looking for. And someone just has to sit down and do that. And then, so thanks for sharing your process. I think you brought up some good points around documentation too, Christine. So we don't have really details from the Department of Ed on what type of documentation they may request in a future audit or enforcement action or something. But it would seem to me that institutions would want to be documenting how you're making these decisions, right? So Christine was talking about that spreadsheet with 50 plus tabs that her nursing expert was working through and really matching up courses with each of the required content areas. I do think institutions need to have that level of detail because you're basing your meets determination or does not meet on that review and analysis by your subject matter expert. So having somebody put that together, that documentation, and then of course retaining it so that it's available, it's, you know, in 5 years, should anybody ever ask for it. Those are important things to be thinking about with this work too, setting up those documentation processes and making sure that it's being retained and would be available should you ever need to produce it in the future. Anybody else have anything you want to share about your research process, how it's going, or if you haven't really dug into this yet at your institution, kind of how you're thinking about tackling it?
Well, this is Jennifer at Washburn again. I guess we aren't subscribers to the bookmark, although it sounds really interesting. So far our program directors have told us that they have information through professional associations or whatnot, you know, as a way of determining, you know, having resources to determine where we meet and do not meet, et cetera. I guess we've been doing this since 2020. So I guess our thing is that just the constant rechecking, you know, the need to always be updating and making sure that it's still the case, and then of course tracking students and such. It's just it's a lot. Seems like there's ours is probably a little too decentralized. We probably need to at least bring the documentation together in a more centralized way so that we have a more formal process to refer to anyway, and central repository of the documentation. Because I think at this point, if we were asked, we'd have to be saying, well, you know, the programs have that documentation, which would be a great thing.
Yeah, and you know, again, there's different ways obviously to set up these processes and work, but I do think, Jennifer, that's probably a good consideration. If you have a decentralized process, maybe you still need to have something that's more centralized, the documentation piece, or somebody who's keeping tabs on when information is being updated, you know, when those decisions are being reviewed again. We don't have, like most of this, I've been saying this all day, we don't have, you know, a prescriptive time frame that the department's provided for how often an institution needs to research what those requirements are for licensure in other states, and, you know, review the disclosure information you're providing. And there's no particular cadence that the department has prescribed for that. But, you know, our recommendation, based on the fact that a lot of these Title IV things happen on an annual basis, right? There's annual reporting required, annual reviews. It does make sense to do it at least annually, that you're having somebody go back in and make sure nothing's changed in states and territories, reviewing that nothing's changed in your curriculum, you know, making sure that those meets and does not meet determinations still make sense. So having an annual process for that, or more frequently, if you're able to somehow keep tabs on changes, but at a minimum, an annual process is probably a good idea. Great. All right, I'm going to shift us here to another question. I'm curious, I talked about initial enrollment a little bit earlier. Any of you want to share what you consider to be that point in time of initial enrollment at your institution for these purposes anyway? Again, knowing that there could be other enrollment considerations or points in time, but what do you consider to be initial enrollment for these licensure compliance purposes. I did go to law school, so I'm really good at just waiting with silence until someone answers. I had several law professors whose that was their tactic, just stand in front of the class and stare at us until somebody would raise their hand.
Well, so this is Jennifer at Washburn again, and I guess I don't know. So I mean, if I had somebody from enrollment management here, maybe they'd be able to chime in. So I don't know if anybody from another institution is from that area. I'm assuming I could call somebody over there and ask, but I don't know that for a fact.
Thanks for answering, Jennifer. I'm guessing you're probably not the only one who is, in that scenario right now. Go ahead, Julie.
This is Julie McAdoo at Ottawa University, and we have always kind of thought of initial enrollment is the point of registration, because the student is going forward. They've applied, they've been accepted. Now they are telling us they're going forward with the program because they're registering in classes. I'm getting the idea though that is a little too late for this particular scenario, that we would have to do those individual disclosures prior and get that attestation if necessary prior to that registration. So I think we would have to rethink it, at least in this context of when initial enrollment is.
Yeah, thanks for sharing, Julie. And that's why I wanted to bring this up, right? As I think there probably are other processes at each of your institutions where there's a point in time that's kind of already been set for enrollment, but that might not be the best point in time for these purposes, especially with the new PPA certify responsibility and how that written attestation could come into play as being required. So yeah, so think about that. If you don't know how your admissions or kind of other facets of the institution, think about that initial enrollment point in time. It's important to be talking about that and thinking it through, and you might need to set up something that's a little bit different for the disclosures and that PPA certification responsibility. I will say, Julie, just so you know, I was meeting with an institution just yesterday who is in the same scenario you just described. So they've always thought about it as when they're registering for classes for that first term. So they're now trying to figure out if they're just going to provide more information way on the front end. So like the direct disclosure, and then start talking. Someone will be talking to those applicants about, hey, you're located in a does not meet state. What are you actually planning to do when you complete the program? Basically trying to filter people out that would not be willing to do a written attestation or couldn't provide a written attestation. But I think they're going to not actually get the written attestation until right before registration. So they're kind of going to have a multi-step process here, which again, the timing on it could all be fine as long as that student has the written attestation completed and you provided direct disclosures before that initial enrollment point in time, whatever that is. So
I know that I have a couple of my colleagues on the call, but one thing that we have discussed is, do we need to put some sort of logic in our online application that is going to kind of start that process you just described of identifying students by their location and according to, our location policy, yet to be determined, but starting it within the application process even.
Mhm. Yep. Excellent things definitely to be thinking through and figuring out and planning, and hopefully able to put at least, get the ball rolling here before July 1 so that you're going to be prepared as soon as you can for that.
If I can jump in, piggybacking off of Julie, because I just talked to our admissions vice president about this. And what his plan is to do is to set up some logic. We use Slate, but to set up some logic in our CRM where students who indicate interest in, or say they're planning on enrolling in one of our licensure programs, if they're in one of these states, which he can, say if they're in these 10 states where we do not meet, to include a paragraph, kind of like a direct disclosure, or an individualized disclosure, saying that we do not meet in this state. So it's even on their acceptance letter when they've first received communication from us that we do not meet in this state. Please contact your admissions rep for more information and to get the ball rolling. But so even in their acceptance letter, they're seeing that we do not meet in that state.
Great, thanks for sharing that, Christine. I'm sure others are also working in Slate or a similar system, so good option to consider maybe your institution too.
Chris, we have a question in the
This
chat.
is- Oh,
Then we'll go to you, Linda. But
Okay.
what about students who late enroll, like after the term or semester started?
Good question. So, Chris, if you want to clarify more, but I'm thinking you're thinking about this like moving forward, not even specifically for this July 1st. But again, clarify if I'm misinterpreting that. So, this is going to apply to any student who enrolls, again, whatever initial enrollment is set at. If that's on July 1st this year or after, then all of these requirements apply. You have to understand if the program meets, you have to certify that it does meet where they're located, and then communicate with them appropriately if needed. So it doesn't really matter, if they're coming in the end of September or something and your classes have already started for fall term, all of this still applies to them equally. But that July 1st date is important because it's that initial enrollment. If it's on or after this July 1st, that's when this new PPA certification kicks in. You should already be doing the communicating, right? Disclosures have been required since 2020, but this big change around certifying is for those enrolling July 1st or after.
Linda, thanks for waiting.
okay. This is initial enrollment at the institution or in the program?
And the program, the licensure
Okay.
program. Yep.
Okay, because our enrollment in programs are quite a bit, a year to two. Well, nursing is at the start of the junior year, so they're accepted at the middle of their sophomore year. So we would have no need to notify them until that point in time, correct?
Correct. You'd have no obligation to send any sort of disclosures until that initial enrollment in the licensure program itself.
Okay, and I'm at Benedictine College, didn't say that, and we have education, and again, they're not accepted into education until sometime in their sophomore year, probably. So we're not going to need to worry about notifying them until after they're already at our institution. So,
yep, I would say thinking through those scenarios, Linda. So if it's a on campus, face-to-face kind of situation where those students are going to be located in Kansas for sure, then
yes, they are.
yeah, so there's not a lot of risk then, right? If we're thinking about risks to the students about having somebody enroll with the intention of going into nursing, and then at the time that they're applying to the nursing program, right, the risk, they're not going to be located outside of Kansas, is what I'm saying, probably based on the way your program is set up and your geography. But for other institutions, if you
no,
have, go ahead.
No, because we draw from all 50 states.
Correct, I understand that, but would they be located on your campus at St. Benedict when they're applying for the nursing program? So like when they're a junior, would they have been on your campus taking classes, or could they
Yes.
have been? Okay.
Yes.
Yeah. So yeah, this again is where student location policy is so important, and you get to set that for your institution. So as long as it's clear that you treat your students who are located on your campus, or taking those programs that require a student to be on your campus, as long as your location policy is clear that you're treating them as located in Kansas, then you wouldn't really have a lot of risk around somebody who's not actually applying to a licensure program until year 2 or 3 of their career at your institution.
Okay, that's very helpful. Thank you.
Yeah, you're welcome. But on the flip side of that, right, some of you may have some risk there if you've got people commuting across state lines, even as commuter students, or if you have hybrid programs, or whatever the scenario is, fully online programs, obviously. But if you've got people who could be located in a does not meet state that's coming in with the intention of applying to a licensure program in year 2 or 3, you may want to think about how can you get information into their hands sooner, like before you're actually obligated to under the regulations, but just to make sure they're informed and understand what could happen right in the future if they need to go through that written attestation process to actually be enrolled. Jennifer, go ahead.
Yeah, so I mean, I think that this might kind of go back to Chris's question too about like late enrollment. So I mean, the main thing here is that with these licensure programs, I mean, you absolutely have to have a stop somewhere. It's not like kids that are just, like you say, coming in as freshmen and enrolling in whatever program that that's like when you go into a licensure program, you've got an application process. There's got to be a stop there, right? That either it's through the online application or through a person. That's where it's got to be caught, right? Where they're going to get the disclosure, and then if they're in a state that doesn't meet, that you do the attestation at that point. The idea like a student enrolling in the fifth week or something like that in a licensure program, somebody's going to know they've just enrolled. I mean, presumably, right? I mean, normally people don't get into licensure programs without some kind of application process. So do I have that right?
Yeah, I mean, I guess that's kind of my assumption too, is right. There's kind of already some heightened things that happen around these types of programs when we're talking about admission. But if you have licensure programs where that doesn't happen and people can just kind of, come in whenever, you would need to look really closely at that and put something in place.
Some kind of process, yeah.
Yeah, because
Right.
you would hate to have people, just rolling in halfway through the semester, but they're located in a does not meet state, and you do have to have something in place to be catching those folks and making sure that they're providing a written attestation, or maybe they just can't enroll in the program if they're in a does not meet state.
That's another good point, right? It's not, the disclosure is not enough. If they're in a do not meet state, you've told them that you cannot enroll them unless they've given you an attestation, right? So that's where the responsibility really lies on us.
Correct. Yep. Again, we're beyond disclosures. Think about it.
Yeah.
It's unfortunately a whole new world now. We're talking about that enrollment ability. So
Thanks.
thank you. Yeah, I see we're at 10:30, actually 10:31. So Nan, if you wouldn't mind real quick, I think the next slide yep. So that's about us. Again, you'll get this if you want to contact us about other services or the bookmark. But we do have one final poll if people want to stick on for a minute here from slido.com 2561206, or you can scan the QR code. We're just wondering, like, what's your focus going to be after today around this work? What's your first order of business? If you want to share that as we close out the session. And we'll get that up here on the screen here in a moment. But again, slido.com 2561206.
Chris, while people are doing that, and hopefully they are. Oh, Sarah, you wanted to say something.
Yeah, I just want to say thank you again, Nan and Chris, for sharing your wisdom and your expertise with us this morning. And just to remind folks that this session has been recorded and the slides will be available probably Wednesday, tomorrow. But if you have any questions, please let me know. And you've got Chris and Nan's contact information. So thank you all for coming today.
Thank you, Sarah.
You want to click on that present link, Nan? We'll show that as people are logging off.
Whoops. I sure will. There we go. It's always interesting to see what people are going to turn to next.
Great. So a lot of focus on policy, student location policy in particular, definitely important. Sharing information, very good. And yeah, formalizing or centralizing the documentation process. So great. Thank you all for being here today. Thank you for your questions and your participation. We appreciate it. And as Sarah mentioned, don't hesitate to reach out to us in the future as you're working through this stuff. And we do hope you can join us for future webinars, including April 30th webinar that MHEC is hosting around this. Sarah had put the registration link in the chat earlier, where you can find that information on MHEC's website. So take care, everyone. Hope you have a great rest of your week.
Thank you.
Thanks.